CNN called the Hawaii case narrow. Bloomberg claimed the outcome was uncertain. Page references show the opposite. The court targeted the entire framework. Page 23 confirms strict application of Bruen without exceptions. Page 29 rejects all forms of government deference. Hawaii's lawyers walked into a trap they built themselves. Their arguments collapsed instantly. The losing side was obvious. Hawaii's private property permission scheme died on contact. Its structure required gun owners to beg for access. Bruen rejects begging as constitutional doctrine. The Ninth Circuit defended that structure. Their reasoning collapsed immediately under scrutiny. Media said the court would balance property rights with carry rights. Reality said something different. The opinion turned the Ninth Circuit's logic to dust. The rule didn't get narrowed. It got destroyed because its foundation was fraudulent. The issue now becomes simple. What in the Hawaii opinion caused the collapse? Where did Hawaii lose control of its narrative? Where did their lawyers fall apart? What did the Ninth Circuit misread so badly? That is where the defeats become visible. Hawaii insisted its new rule matched historic tradition. They claimed old trespass laws supported their ban. This assertion failed the Bruen test instantly. It was a lie of convenience. Historical records show property owners could remove unwanted guests. Trespass laws back this up. No one disputes that basic right. What is missing? Any tradition of states imposing universal criminal bans on carry. No founding-era examples exist of states banning guns by default on commercial property. That difference matters critically. Bruen asks if modern regulations match historical ones. Hawaii can't show the match. News reports called Act 52 a simple safety rule. Wrong. Act 52 was a direct attack on the right to bear arms. It flipped the constitutional default rule for property access. The previous default was clear. Carry was allowed unless specifically prohibited. Hawaii inverted this completely. Now carry is banned by default unless property owners post a specific sign. Hawaii's strategy was pure evasion. They tried to create a gun-free zone default nationwide. The Ninth Circuit bought the state's argument. They failed Bruen's test completely. One brief called it exactly what it is. The default rule was invented to undermine carry rights. It lacks legitimate historical support. Hawaii's lawyers could not dispute that claim effectively. This legal move is what petitioners argued was a complete misuse of the Bruen test. They're right. The state tried to substitute private choice for state command. That switch demolishes the Second Amendment. The court saw this trick immediately. They recognized the state forcing property owners to opt into the Constitution. That structure is inherently unconstitutional. It makes the government the gatekeeper. Hawaii's defense was circular. They cited old laws allowing exclusion. Quick thing. Please hit that subscribe button right now. Helps me keep breaking down these cases for you. Thanks. Now back to what we were saying. They then jumped to claim the state could enforce universal exclusion. The logic collapsed on itself. The court made the mandate clear. The government must show a regulatory tradition. The power of a private owner is irrelevant to state regulatory authority. The state is what regulates. The Ninth Circuit's argument collapsed completely. They accepted a theory letting Hawaii do indirectly what Bruen banned directly. The court found this unacceptable. The lower court claimed owners always could exclude guns. True, but they found zero historical examples of states enforcing universal criminal default bans. None existed. That is not interpretation. That is defiance of Supreme Court authority. 8 Ninth Circuit judges dissented strongly. They accused their own court of giving the Supreme Court a judicial middle finger. Those are their exact words. The Ninth Circuit admitted Hawaii is mostly private land. They saw no problem with eliminating nearly all carry space. That's the failure right there. It guts the right to bear arms. The dissenters hammered this point home. They called the ruling a complete refusal to apply Bruen. The majority opinion simply ignored the historical evidence presented. The Ninth Circuit upheld Act 52. Their opinion failed immediately upon review. They twisted the property rights argument. This was a clear attempt to preserve May-issue logic. The Supreme Court took the case in October 2025. They are going to settle this issue decisively. The Ninth Circuit's defiance ends here. Taking the case signals the court will resolve this conflict The collapse of the Ninth Circuit's ruling is inevitable. The state's argument relied on wishful thinking and evasion. Hawaii tried to achieve total disarmament in public spaces. They used private property law as a shield. The court's authority is absolute here. The shield failed. Justice Thomas set one clear rule in Bruen. Page 18 lays it out clearly. Gun regulations must be consistent with the historical tradition of firearm regulation. That is the only test. The Ninth Circuit ignored this test. They invented a mechanism to evade it. The court's rejection of the evasion signals its power. The Constitution dominates here. The Second Amendment protects the right to bear arms publicly. This right cannot be eliminated through regulatory cleverness. The court established that hierarchy. Hawaii could not point to a single founding-era law creating a default carry ban on public commercial property. This omission destroyed their entire case. History is ruthless. The state tried to argue that general property rights were enough. They said property owners are always sovereign. The state is not the property owner. That is the core difference. The state's power must be independently justified by history. It must be consistent with the tradition. Hawaii failed to meet this burden. The burden shift is now permanent. Bruen makes the government prove its case. Hawaii had to prove their ban was a historical twin. They presented a phantom twin. The evidence vanished under scrutiny. The entire legal elite predicted Bruen wouldn't change much. They were completely wrong. Bruen instantly exposed these clever state schemes as fraudulent. The lower courts failed to read the opinion correctly. They clung to old balancing tests. The Supreme Court crushes that resistance. The law is the law. The rule is nicknamed the vampire rule for a reason. It turns most of the state gun-free by default. It requires an affirmative invitation for constitutional exercise. The rule operates silently, like a vampire. It requires the right to be specifically invited in. That inverts constitutional principle completely. The Bill of Rights is a default. Petitioners called the rule a legislative sleight of hand. They argued it was designed to maximize the friction of carry. They are right on both counts. The state's objective was making carry practically impossible. They wanted to turn Hawaii into one giant, undeclared gun-free zone. They nearly succeeded. The Ninth Circuit's opinion admitted that Hawaii is mostly private land. They saw no problem with eliminating nearly all carry space. That's the failure right there. It guts the right to bear arms. The court saw through the property rights excuse. They recognized it as a land use regulation targeting arms. Land use regulations must also pass Bruen. They did not. The argument that property rights are unaffected is a lie. Quick thing, please hit that subscribe button right now. Helps me keep breaking down these cases for you. Thanks. Now back to what we were saying. The state is criminalizing conduct on private property. That is state action, not private exclusion. This whole attempt was a masterclass in legal arrogance. Expert lawyers thought they could outsmart the Supreme Court. They failed publicly. The dissenters emphasized the chilling effect. The rule criminalizes activity unless specifically authorized. This is anathema to a constitutional right. What does the opinion establish about state power to eliminate constitutional rights through clever wording? It establishes the Constitution reigns supreme. The state cannot use legislative tricks. The entire framework relied on a false parallel to trespass law. Trespass is about specific orders. This rule is about general criminal prohibition. The differences are fundamental. The state tried to make the gun owner responsible for navigating the maze. Every piece of property became a potential trap. The court shuts down the maze. The justices understand the reality of carry. If the right cannot be exercised in commercial areas, it is not a right. It is a theoretical abstraction. The collapse of this rule is a victory for clear doctrine. It shows the limits of state legislative power. The limits are the text and history of the Constitution. The state's argument that owners need signs is backward. The right exists without signs. The prohibition requires signs and historical justification. The Ninth Circuit missed the obvious power hierarchy. The Supreme Court dictates constitutional interpretation. Lower courts must follow precisely. Defiance is pointless. The court's mandate ensures that the Second Amendment is not a second-class right. It receives the same protection as the First Amendment. No state can invent a trick to silence speech. Similarly, no state can invent a trick to eliminate carry. This case confirms that dominance. State schemes fall when facing the Constitution. The story around Hawaii's vampire rule follows a familiar pattern. Gun control advocates oversell their legal position to media and donors. They build complex structures on thin doctrinal ice. They relied on lower courts to indulge creative limitations. Then a Supreme Court case forces real application of Bruen. Their elaborate constructions look flimsy and contrived. Historical tradition is missing. Founding-era support does not exist. The entire strategy stands exposed as an attempt at evasion. Gun-free zones were always more political than historical. Permission schemes were always more obstructive than protective. Safe spaces rhetoric hit a simple objective: make carry impossible practically. A ruling against Hawaii would not be a small adjustment. It marks the collapse of a carefully built workaround system. Everytown, Brady, and their allies understand that fully. Their own fears, stated plainly, confirm who stands to lose most. Media outlets predicted momentum and control. In doctrine, their central tools face potential eradication in one case. Wolford v. Lopez is not just about one island statute. It is about the survival of gun control zoning as a national strategy. If that strategy falls, the map changes forever. The burden shifts completely. The hierarchy clarifies absolutely. The Constitution dominates campaigns. Doctrine dominates messaging. Rights crush workaround schemes. Media outlets confidently predicted Bruen wouldn't change much. Gun control groups repeated this claim. They were completely wrong. The collapse is visible nationwide. Lawyers defending these schemes had no answers for the historical test. They punted to general property law. That is not an answer under Bruen. It is a confession of failure. Their entire strategy was to distract the court from history. They tried to create a modern necessity argument. The court crushed that balancing test years ago. They simply did not learn. The professional class of gun control advocates failed their clients. They built a defense on sand. The first wave of judicial review washed it away completely. Their confident claims about public safety are irrelevant to the test. Bruen cares about history, not feelings. The Constitution must be obeyed, not negotiated. This repeated pattern shows a profound arrogance. They refuse to accept the court's clear mandate. They think they can legislate around it. They are consistently defeated. The loss of this case proves the power of the Second Amendment. It shows the Constitution cannot be undermined by legislative trickery. The court demolished the scheme. The failure is a lesson for state attorneys general. Do not defy the Supreme Court. Do not invent history. Do not rely on lower court indulgence. The dominance is real. The outcome demonstrates the failure of their legal imagination. They could not find historical justification. They substituted sophistry for evidence. The sophistry collapsed. The court targeted the core weakness of these schemes. They rely on the absence of carry space. The right to bear arms requires space for exercise. The state eliminated that space. This opinion establishes a clear principle. The state cannot use zoning to eliminate a constitutional right. That action is direct infringement, regardless of clever wording. The victory confirms the supremacy of the Constitution. The defeat confirms the fraudulent nature of the vampire rule. The map for concealed carry changes now. All states must recognize the constitutional dominance. All lower courts must stop resisting Bruen. The text and history of the Second Amendment prevail finally. The hierarchy is settled. The Constitution wins. If you want to see the next case breakdown, click the video on your screen right now. It's right there. Just tap it or click it. I'll show you the next court ruling and what it means for Second Amendment rights.